Falling object injury lawyer, New York City. Know your rights. Attorney Andrew M. Stengel. A falling object can change your life in seconds. Across New York City, people suffer serious injuries when bricks, merchandise, tools, and construction debris strike them without warning. These accidents happen on sidewalks, beneath aging buildings, inside retail stores, and near active job sites every day. If a falling object hurts you in New York, a property owner may owe you significant compensation. Premises liability law holds building owners, retailers, and contractors accountable for the overhead dangers they created or ignored. This post explains your rights, who bears responsibility, and what steps to take after a falling object injury in New York City. New York premises, liability law, and falling objects. Property owners in New York have a legal duty to keep their premises safe for pedestrians and all lawful visitors. That duty extends to overhead spaces, not just floors and walkways. When an owner knows about a dangerous condition and fails to fix it, the law treats that as negligence. New York courts require proof of actual or constructive notice in falling object cases. Actual notice means the owner knew about the hazard directly. Constructive notice means the hazard existed long enough that a reasonable inspection would have caught it. Furthermore, owners cannot plead ignorance when inspection reports document dangerous conditions. Additionally, New York follows a pure comparative negligence standard. Even if you share some responsibility for the accident, you can still recover damages. Your compensation is simply reduced by your percentage of fault. This rule protects injured New Yorkers in a wide range of situations. When New York City building owners are responsible for facade failures, New York City's local law 11 requires owners of buildings taller than 6 stories to inspect and maintain their facade exteriors every 5 years. A qualified inspector must evaluate the exterior, and owners must repair any unsafe conditions identified. Despite this requirement, facade failures continue to injure pedestrians across all 5 boroughs every year. Crumbling bricks, falling cornices, and detaching architectural elements strike people on sidewalks below. When this happens, New York City Department of Buildings violation records become critical evidence. They establish that an owner knew about deteriorating conditions and chose not to act. Therefore, failing to repair documented hazards is not an oversight. It is evidence of clear negligence. In addition, owners who skip required inspections face both civil liability and potential criminal penalties. Ignorance is not a defense when the law mandates regular inspection and maintenance. Retail stores, construction sites, and New York labor law. Retail stores throughout New York City must properly stack and secure merchandise at all times. Store employees must follow safe stocking procedures and regularly inspect shelving systems. When improperly stored items fall and injure a customer, the store faces a premises liability claim. Heavy boxes, electronics, and building supplies cause severe injuries when they fall from even the lowest of heights. Importantly, security footage showing improper stocking practices can significantly strengthen your case, but that footage typically overwrites within a few weeks, if not sooner. So, acting quickly is essential to your potential falling object's personal injury lawsuit. Construction sites present equally serious dangers. Workers injured by falling objects on New York job sites may have a claim under Labor Law Section 240, 1, also known as the Scaffold Law. This powerful statute imposes absolute liability on property owners and general contractors for gravity-related accidents. As a result, injured workers do not need to prove negligence to recover compensation under Section 240. Pedestrians and bystanders near construction zones pursue standard premises liability claims instead. Property owners must maintain proper safety barriers and protective netting around active sites. Failing to secure a work zone demonstrates negligence when falling debris strikes someone outside the perimeter. Frequently asked questions about falling object injuries in New York. How long do I have to file a falling object lawsuit in New York? Most falling object personal injury claims carry a 3-year statute of limitations in New York. However, if the property owner is a government entity, such as the City of New York or the MTA, You must file a notice of claim within 90 days of the accident. Missing this deadline can permanently bar your claim. Contact an attorney as soon as possible after your injury. What evidence should I preserve after a falling object accident? Photograph the object, the location, the surrounding conditions, and your injuries immediately, as long as it is safe to do so. Seek medical attention first. Then contact an attorney quickly. Your lawyer can send a litigation hold letter to preserve security footage before it overwrites. Inspection records, witness statements, and Department of Buildings filings are also far easier to gather in the days right after an accident. Can I recover damages if I was near a construction site voluntarily? Yes, in most cases. Property owners must protect both workers and members of the public from construction site hazards. Your decision to walk near a construction zone does not automatically make you responsible for an injury caused by an unsecured site. New York's comparative negligence rules give courts flexibility to apportion fault fairly. Injured by a falling object? We will fight for you. A falling object injury is overwhelming, physically, emotionally, and financially. However, you do not have to face New York's premises liability system on your own. The law firm of Andrew M. Stengel, PC, represents victims injured by falling objects throughout New York City, including Manhattan, Brooklyn, Queens, the Bronx, and Staten Island. We know how to gather evidence quickly, identify every responsible party, and build a case that demands full compensation for your medical bills, lost wages, and pain and suffering. We work on a contingency fee basis. You pay nothing unless we recover for you. Contact us for a free, completely confidential consultation. Email info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.